her attorney said that we should get those by the end of next week. Justin Baldoni's attorney, Brian Friedman, we heard a little bit about their plan, too. He talked about how they want this case moving forward as quickly as possible.
I can't have this getting out. These words reportedly echo through Blake Lively's legal strategy as her team aggressively pushes for extraordinary confidentiality measures in her battle with Justin Baldoni. While celebrities regularly claim they want privacy, the level of secrecy Lively demands exposes something far more calculated. Court documents show her legal team citing threats and harassment as justification for their extreme protective order request. But our investigation reveals connections to high-profile celebrities that might be the real reason behind this unusual legal maneuver. Stay with me as we expose what Lively doesn't want you to see. Is Hollywood royalty getting special treatment in court? Blake Lively's legal maneuvers are raising eyebrows as her team pushes for extraordinary confidentiality measures that go well beyond standard court protections. This isn't just about keeping a few private details under wraps. It's about creating an entirely different standard of justice for the celebrity elite. In recent court hearings, Lively's attorney, Meryl Gavrnsky, made the case for an attorney's eyes-only designation for sensitive discovery materials. This isn't your typical confidentiality request. It's a high-level protection that severely restricts who can view the information. Gavrnsky's justification? That dozens and dozens of third parties could be identified in these materials, potentially exposing their private conversations and connections to public scrutiny. But Justin Baldoni's legal team isn't buying it. His attorney, Brian Friedman, fired back that the existing protective order is more than adequate to safeguard truly sensitive information. Friedman didn't mince words, calling Lively's requests offensive and suggesting they represent a troubling double standard in our justice system. The message was crystal clear. Celebrity status shouldn't entitle anyone to special treatment in court proceedings. The clash highlights a growing tension between celebrity privacy demands and the foundational principle of transparency in our courts. The judge overseeing the case pointedly referenced the presumption of public access to court proceedings, a reminder that our legal system was designed to function in the light of day, not behind closed doors accessible only to a privileged few. Let's be real about what's happening here. This isn't just about protecting Blake's personal information. It's about shielding an entire network of Hollywood elites from being associated with this increasingly messy legal battle. When Gavrnsky specifically mentioned protecting dozens and dozens of third parties, she revealed just how interconnected the web of relationships is among Hollywood's most powerful players. What's particularly telling is how hard Lively's team is working to create a protective bubble around not just any third parties, but specifically high-profile individuals unrelated to the case. This suggests the discovery materials likely contain communications with some of entertainment's biggest names, people who would prefer to stay far away from this growing scandal. Baldoni's attorney pushed back against the celebrity shield, bluntly stating, "We see no difference because someone is a celebrity," and how the case should proceed. This stance represents a fundamental challenge to the notion that fame should buy special treatment in our courts. In Friedman's view, the rules that apply to ordinary citizens should apply equally to those with star power and million-dollar legal teams. The question hanging over these proceedings is what exactly has Lively's team so concerned? What communications are they desperately trying to keep from public view? What names appearing in these materials would cause such irreparable harm if revealed? The extraordinary measures being sought suggest the stakes are unusually high, even by Hollywood standards. Those extraordinary measures Lively's seeking aren't just about courtroom procedure. They're ammunition for a full-blown PR war happening behind closed doors. Court documents expose an alarming reality. Blake's team isn't just fighting a legal battle, they're fending off what they describe as a calculated character assassination campaign with seemingly unlimited resources. In stark legal filings, Lively's attorney, Meryl Gavrnsky, didn't mince words, claiming the defendants are actively trying to ruin the lives of Miss Lively and her family, with what appears to be an unlimited budget dedicated to their destruction. This isn't typical Hollywood hyperbole. Her spokesperson doubled down on these assertions, stating the defendants have committed to spending $100 million to destroying Miss Lively and her family. That's not lawsuit money. That's destroy a reputation money. The accusations get even more disturbing. Lively's team alleges the defendants have actually bragged in text messages about being able to publish information without fingerprints. Let that sink in. They're not just accusing the other side of playing dirty. They're suggesting there's a coordinated campaign to leak damaging information while covering their tracks. This reads less like standard legal maneuvering and more like corporate espionage. The high-stakes nature of this shadow war becomes crystal clear when you look at who Lively has brought onto her team. She didn't just hire any crisis manager. She recruited Nick Shapiro, former CIA chief of staff turned PR heavyweight. You don't bring in ex-intelligence personnel unless you're preparing for information warfare on an unprecedented scale. Even the judge overseeing the case, Louis Lyman, seems concerned about how this PR battle could contaminate the legal proceedings. He's already issued warnings to both legal teams about making fiery public comments that might compromise the possibility of a fair trial. The courtroom may be the official battleground, but the real fight for public opinion is happening on social media, in tabloids, and through strategic leaks. What makes the situation particularly dangerous for Lively is the timeline. With the trial date set for March 2026, nearly 2 years away, there's an enormous window for damaging information to leak. Drip by excruciating drip, each new revelation becomes a fresh news cycle, a new viral moment. This explains why Lively's team is pushing so urgently for extraordinary protective measures. It's not just about the trial. It's about surviving the next 24 months with her reputation intact. Some evidence has already escaped the confidentiality net. Text messages released by Baldoni's team have already pulled Taylor Swift into the fray, with Lively allegedly referring to herself as Khaleesi and mentioning Reynolds and Swift as my dragons in private communications. These Game of Thrones references might seem harmless, but they hint at something potentially more damaging: the existence of candid, unfiltered communications that could embarrass not just Lively, but her entire social circle of A-list celebrities. The text messages that have already surfaced may be just the tip of the iceberg, playful references that don't cause serious harm, but their release signals what could be coming. Increasingly personal communications that reveal how Hollywood's elite really talk when the cameras aren't rolling. For someone like Lively, whose brand relies on a carefully crafted public image, that prospect isn't just concerning, it's existentially threatening. Beyond those harmless Game of Thrones texts lies the real battlefield where Blake's reputation hangs in the balance. Her legal team isn't just battling for privacy. They're specifically fighting to keep 3 explosive categories of information sealed tight from public view. These 3 areas tell us exactly what Lively is most desperate to protect: security measures, medical records, and communications with high-profile third parties. When a celebrity fights this hard to keep certain documents hidden, you have to wonder whether she's protecting legitimate privacy concerns or something far more damaging. Let's start with the security measures. Baldoni's team has already served a subpoena on Lively and Reynolds' security firm, a curious move for people who claim to have no interest in those details. This contradiction exposes a potential strategy. If Baldoni's lawyers can show inconsistencies in how Lively protects herself and her family, it could undermine her claims about feeling threatened during the film production. The security records might reveal that the protective measures she's taken don't match the level of distress she's claiming in court. Then there's the medical information, particularly related to mental health. According to Meryl Gavernsky, disclosing this information could pose a significant risk to her client. Here's where things get interesting. Lively's lawsuit includes claims of emotional distress, but what if her medical records tell a different story? If there's inconsistency between her public claims and her private medical history, it could devastate her case. The question becomes whether these records support her claims of distress from the film production, or if they might suggest other causes for any documented conditions. Most explosive of all might be those communications with high-profile third parties. Hollywood is a web of power and influence, and these communications could reveal how stars coordinate their public statements and private actions. If messages show Lively strategizing with other celebrities about how to handle the situation with Baldoni, it could transform this from a case about workplace misconduct to one about industry blackballing and power plays. The extreme protective measures suggest Lively might be hiding evidence that could potentially undermine her claims or expose contradictions in her public statements about the film production. The New York Post has already suggested that these sealed documents could contain information that directly contradicts Lively's version of events on the It Ends With Us set. We've all seen celebrities carefully craft their public personas, smiling on red carpets while their private realities might tell entirely different stories. The battle for these sealed documents represents more than just privacy. It's a fight to control narrative. If her private communications reveal her speaking differently about Baldoni or the production than she's claimed publicly, her entire case could crumble. What makes this particularly fascinating is the judge's commitment to the presumption of public access to court proceedings. This legal principle means that, barring exceptional circumstances, The public has a right to see how the judicial system works, including the evidence presented. By pushing so aggressively against this transparency, Lively's team is essentially arguing that her celebrity status should override this fundamental principle of our justice system. When the gavel finally drops in 2026, it won't just be about the legal arguments. It'll be about who won the battle for public perception. Legal experts confirm that celebrity status fundamentally alters courtroom dynamics, creating a media spectacle where public opinion can influence legal strategies just as much as case law. The statistics don't lie. Protective orders like the ones Blake is fighting for get approved in about 70% of similar high-profile cases. But that special treatment raises serious questions about justice in America. Are celebrities entitled to extra protections ordinary people couldn't dream of receiving? As this Hollywood drama continues playing out, we're witnessing more than just another celebrity squabble. We're seeing the raw power of fame manipulating our judicial system in real time. Blake might claim she's simply protecting her privacy, but the extraordinary measures she's pursuing suggest there's something far more damaging at stake than just her public image.